All right, everybody, so welcome. So our training today is explaining Permanency Planning Committee meetings, known as PPC meetings. And I'm super excited because we've got Moira Dillon from the division here to present to us and kind of give us the perspective from DFS about Permanency Planning Committee meetings. So Moira, I'll turn it over to you.
Thanks, Lauren. Hi, everybody. I'm so glad to be here. I just was saying to Lauren how much I wish we were in person. It's so much more. I just enjoy being in the room with everybody so much more, but I'm so glad that we have this opportunity to gather in this way. And I just thank you again, Lauren. I know that, so the Permanency Planning Committee, which is what we're going to talk about today. Well, let me say, first, my name is Moira Dillon, and I'm the Adoption Program Manager with the Division of Family Services. And I worked as a worker for many years. I was an adoption worker. I was a treatment worker prior to moving into this position. And I've been in this position, I guess, for about 2 years now. But one of the things I remembered is that the first time I went to the Permanency Planning Committee, there was never, I was just told, oh, you have to take this case to this committee. There was never any what is the committee? Who attends the committee? What is the purpose of the committee? So, and I'm not sure, some of you may have had that same experience. I'm sure that in the work that you're doing in the child welfare system, you've probably already gone to PPC, the Permanency Planning Committee, or will expect to go in the future if you're new. But so my goal is to really provide you with an overview of what the Permanency Planning Committee is. Lauren, can I share my screen at this point?
Yep, go for it. You should see your that little green button at the bottom that says share screen.
Okay. So that is really my goal today, is really to, if I move this, are you guys seeing, I'm sorry, I'm not very familiar with Zoom. If I move anything, do you guys see what I see?
We see your, looks like the first page of your PowerPoint.
Okay, good. I just moved all of you guys over to that screen, and I wasn't sure if you saw that. Okay, so so thanks again for being here. I want to talk about the Permanency Planning Committee, also called the PPC. And again, my goal is just to provide an overview of what PPC is and who makes up the Permanency Planning Committee, and when and how a case should be presented to PPC, and what the PPC is looking for. Certainly we cannot cover everything, but I'm hoping that we can cover the basics and give a general understanding of what the committee is. I wish if somebody had given me a general understanding, but that's pretty typical DFS. You kind of learn as you go, right? So, okay. And, we're a small group. We're really informal. I wish we were in the room together, but please feel free to cut me off at any time to ask questions, or put a question into the chat. It's just a pleasure to, I said to Lauren before, I miss working with our community partners. So thank you again for allowing me to be here with you today. So the PPC was born from the Adoption and Safe Families Act of 1997. And this is, you probably have heard it referred to as ASFA. And this is really a very important landmark in federal child welfare law. It establishes that our national goals for children in the child welfare system are safety, permanency, and well-being. And here are our key principles of ASFA. Child safety is paramount. Foster care is temporary. Permanency planning starts when a child enters foster care, when a child first enters the foster care system. And child welfare should be outcome oriented. And this really came from the days of when children would just languish in foster care, right? They would just be in foster care for years, and there was really just no oversight or accountability. So this is really, really very important. And so what is the Permanency Planning Committee, also known as the PPC? And it is a multidisciplinary team created to consider the best interests of a child or youth in foster care, and also to recommend guidance for case direction related to the child's permanency plan or goal. So I'm going to take a timeout real quick and just talk about those two words. You're going to hear me use the word plan, and you're going to hear me use the word goal. And you probably are hearing that when you're in the courtroom and when you're having team meetings. And for a really long time, we've used the word goal. And I have to say, I'm not really sure where that word came from. ASFA uses the word plan. We use and focus, when we do a lot of our work in our system, it requests the goal. And more though, you're going to hear us refer back to the word permanency plan. And I think that's a better word, because we're planning. We are setting goals for our youth, but we're planning with them. So you're going to hear me use both words, plan and goal. You're going to hear the courts use it. You're going to hear the workers use it, but they mean the same thing. So let's talk about who is on this committee, because I'm guessing that, and I know this was my experience, Lauren and I talked about this a little bit before. I'm guessing that if you have been to PPC before, that there's a table of people and you don't really know who's there. And sometimes we have name tags if we're in person, but we don't have name tags when we're not in person. So I'm going to tell you real quick who is a member of the committee. It's going to be the regional and assistant regional administrator in the region that the case is being presented. You're going to have your permanency supervisor, and also other supervisors not directly involved in the case, often are treatment supervisors in that same region. Program manager, which is me. There'll be a deputy attorney general that sits in. Your foster care supervisor, and your permanency coordinator. The permanency coordinator is the person who, if you've participated in the past, it's Kathy Kearns, and she takes notes. And so she attends each one. You're going to have a representative from prevention and behavioral health, and also one from youth rehabilitative services, because this is a department committee. This is not, it's heavy DFS folks, but it is, we also have representation from our sister divisions. And you have to have 5 voting members for a quorum, and we'll talk about the vote too. The permanency supervisor chairs the committee. So they're the one that they kind of call the meeting to attention. They pull all the materials together. They make sure that the committee has all the materials in advance, so that they're not just coming in and listening to the presentation. They have all the materials that we're going to talk about before the presentation, so that they can prepare for it. The DAG and any supervisor related to the case do not vote. And what I mean by, so you may have a treatment supervisor who is a voting member, but if a case from their unit is being presented, they are not able to vote. They cannot vote on their on a case in their unit. And the committee meets 5 times a month. We meet twice in New Castle County, and that is on your second and last Thursday of the month. We had PPC this morning in New Castle County, and we meet twice in Kent. I think I write down the second Tuesday, and I believe the 4th Monday of the month, and once in Sussex, it's always the 1st Wednesday of the month. And the worker is going to present the case in their region. And what I mean by that is, if your case is in Kent County, it's not going to be presented in Sussex County. I always had a hard time with that when I was a worker. If I was in New Castle County and I needed to present a case, but I couldn't go on the 2 days that were available, why couldn't I present in Sussex? But the cases are only reviewed in the region that the case is in. Okay, so when does a case get referred to the Permanency Planning Committee? So I want you to think about the case that you're involved with, or cases that you're involved with, and if that child or youth has been in foster care for 10 out of 15 months and reunification has not yet occurred, that case will be presented, and the worker will get notified. But we know how long our kids are in foster care, and the courts, we talk about it in court, we talk about it in supervision. But the worker will be notified when it's time to come to PPC, Permanency Planning Committee, and even if, you know, a case is where you're not looking to change the permanency plan, but a child has been in care for 10 out of those 15 months, then the case should still come to Permanency Planning Committee to be reviewed. You're also, that's going to be, you're going to refer when there is a consideration of a plan or a goal change. That could be any time in the case, right? And I would encourage, I hope that you have all been part of team meetings, and I hope that team meetings are taking place before a case is referred to PPC for a plan or a plan change. And if not, please feel free to request a team meeting to the DFS worker. We also present to the committee when selecting a permanent guardian or an adoptive resource for a child or youth. And we're going to talk in a little more detail about this later. And then finally, if DFS is requesting to be excused from planning with the parents, the case will come to PPC. So let's talk about this for a minute. When would we ever request to not plan with a parent? And so on the screen is what you see is called an early screening guide. And this is just a guide that our workers use. And these are questions that the workers will consider after the preliminary protective hearing. Have the parents indicated that they would like to make a plan for adoption? And have either of the parents been convicted of a felony level offense against a person in which the victim was a child? Has the child been subjected to torture, chronic abuse, sexual abuse, and/or life-threatening abuse by a parent? Has there been a prior involuntary termination of parental rights over a sibling of the child or youth? Has the child suffered serious injury? Are the parents' whereabouts unknown? And if the worker or if you are able to answer yes to any of these above, now we're not going to necessarily ask for it in every case. The worker will speak to their supervisor and the DAG on the case about whether a referral to PPC is appropriate for no reasonable efforts or to be excused from case planning. And this needs to be done prior to the dispositional hearing, just because once the case plan has been signed, it's really difficult to request no reasonable efforts. So I'm going to stop. I can't see the chat, so I don't know if there's any questions, but I'm just going to take a quick break and see. That's a lot of information. Does anybody have any questions right now?
Laura, this is Lauren. I have a question about the no reasonable efforts.
Mm-hmm.
How does this sheet, this early screening guide, translate to a court hearing, or how does DFS determine it, or if and when DFS determines that no reasonable efforts need to be made, how does that get to the court or in front of a judge?
Yeah, that should be, they should come to, that's a great question, Lauren. The case, if the worker and the supervisor, after speaking to the DAG, decide they want to explore no reasonable efforts, they're going to come to PPC and request it, and then they would request that the DAG file a motion for no reasonable efforts. So
I
this
have a question.
Is simply a guide for the worker.
I have another question. If there is a physical injury to a child, and there is a criminal investigation going on at the same time, which most of the time there is no outcome before the dispositional hearing, most of the time, because it takes a long time, how do you proceed?
That's a really good question, because it's not, and we run into that a lot, don't we? That we aren't able to proceed because we don't have the outcome, and sometimes our cases really do get delayed as a result of that. And so but again, it says, has the child been subjected? So it is something that we can still explore and would get direction from the attorneys involved in the case.
Well, most of the time when children cannot speak, so I'm talking about infants, children under 2 or 3,
yeah.
When they have a physical injury, they are not able to express what went on or who did what.
Mm-hmm.
So the dispositional hearing will be delayed until they have an outcome of the criminal investigation?
No, the dispositional will not be delayed, and often what might come of it, and this is, you know, our cases are also unique, right? But what might come of it is that the DAG says, no, don't file that, and we are going to case plan, and we'll go through the steps of the case. So no, we would not delay our case, but sometimes it does hold up the process.
Mm-hmm.
But it may just be a decision is made that we are going to case plan.
Okay.
Really good question. Thank you. This one's a really like sticky area, right? And
yes, it is.
That's where I always say, well, you want to talk to, you know, the child attorney, you want to talk to the DAG. You know, those are really, there are resources for that. And they are, again, they sit in on the Permanency Planning Committee. And often the DAG who is involved in the case will be there or has provided input and can say, no, we're going to plan. But this is kind of a guide. This is not kind of, this is a guide for workers. And if they just choose to not case plan. But we get stuck in that is that you're right. It's not founded. Nobody's been, you know, I say founded, but in a criminal trial, nobody's been convicted of anything at this point. So it's really hard. Any other questions?
Yeah, can I assume that under no reasonable efforts, if birth parents essentially say that they aren't interested in case planning, you know, the state's against them, blah, 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 that by definition, that's no reasonable effort?
Yeah, I mean, the parents can certainly choose not to case plan.
And so can that then be brought earlier, you know, because of no reasonable effort?
Yeah, I think so. Yeah, I mean, I'm always on the back end of cases, but I've certainly seen that with cases that were, you know, adoptive families, unfortunately, and say we don't want to plan, and that really falls under number one. Have the parents indicated a plan for adoption? Sometimes not. Sometimes it's not a formal decision for no reasonable efforts, or it's just the family says that I chooses not to plan. And that doesn't have to be something that we file in the court, if that makes any sense.
I'm sorry, Maura, what I think, and Ann, you can correct me if I'm wrong, I think what you might be talking to is a failure to plan on the parents' part, not the reasonable efforts is that DFS needs to make reasonable efforts to reunify, but what you're
yeah.
In the case where a parent declines or doesn't work on the elements of their case plan. That would be failure to case plan. So I think that's what I'm hearing from you.
Right. Last summer we had a case like that, but they also had the added prior involuntary termination, Sam, right? You know who I'm talking about?
Yeah.
But let's say that piece of it hadn't been there with those parents, number 4, right? But those parents strongly indicated they had no interest in working with the state, to case planning, whatever. Would that have been a reason to bring it to?
Probably not. I suspect that the parents this happens very often in our cases, right? That the parents are just not on the scene, but we wouldn't file for no reasonable efforts because, like Sam said, that means that we don't have to we don't have to help the family plan, but if the family came back and said they wanted to plan and the case was still open,
at any time,
we could give them that option. Correct.
Okay.
Yeah, correct.
Now, Maura, one last question. I don't know, it might just be semantics, but are no reasonable efforts and then being asked to be excused from case planning, is that just 2 different ways to say it, right?
It is, and that's always confused me too.
Okay.
Yeah, it is just 2 different ways to say it, and they mean the same thing, kind of like what I said at the beginning about plan and goal. But yeah, that's always bothered me.
Okay, thanks.
Call it one thing or the other. Yeah, we like to confuse folks at the division. You know that about us. Okay. So let's talk, and I just jumped in. There's any other questions about failure to plan, no reasonable efforts? Okay. So here are, up on the screen, are our permanency goals and plans. Because often when we talk about permanency, we think about adoption. But A child or youth's first permanency plan is always reunification. That is always, we think the best option. Other plans are termination of parental rights and adoption, permanent guardianship, guardianship with known resource, and guardianship with unknown resource, and also APLA, which is another planned permanency living arrangement. And we know that APLA is the least sought after goal, and we really do need to make every effort for a youth to exit foster care by any other plan. We really need to rule out every other plan before considering APLA. And if APLA is selected, the worker must be prepared to discuss compelling reasons. So here are some examples of compelling reasons why APLA is the best plan for a youth. One is that a youth is 16 years old and does not want to be adopted. They have verbalized that they do not want to be adopted. And I hope that this was not a one-time conversation with the youth about adoption, that we don't ask them if they want to be adopted and they say no, and the case comes for a goal change, that we really need to figure out why the youth is saying no, and that's a whole other training. So a second compelling reason is the parent and youth have a significant bond, but for whatever reason, the parent is unable to care for the youth. Another is that diligent efforts have been made to achieve other permanency plans, and the youth is in a stable and committed long-term placement where the other permanency options have been ruled out. And this one's probably the very common is they have resided with a foster parent who has made the decision that they do not want to adopt or do permanent guardianship for whatever reason, and so that is, and the child is not likely to move from that placement, from that home. And finally, the youth has a documented inability to be maintained in a family, or documented inability to be maintained in a family setting as and documented by professional assessment. And it includes, but is not limited to, a psychiatric or a psychological assessment. And a worker must have 3 compelling reasons for APLA to be considered. And I know that we really talk negatively about APLA, but I do think that, and I might be alone in this, but there is a place for APLA, because even if the plan is APLA, we're still talking to children about adoption and about guardianship. We're still talking to families. Really, what it is that it. Oops, sorry. Did I go way fast? Really, we're trying to make connections. So I know that there is thought that APLA is like the end of the road, but it's not. It's we're still required to make connections, and we're thinking now about relational permanency, sometimes not legal permanency. That's a whole other training too, but ultimately, the plan really does become supporting our youth and helping them make lifelong connections, because what is my worst fear, and probably some of yours too, is our older youth who age out of foster care and they don't have anybody. So when we look at plans of APLA, we've got guardianship with an unknown resource. Really, our plan is to support our youth and helping them identify who those lifelong connections are when they exit the foster care system.
So I have a question about that. We're talking about our older teenagers, I assume. And my experience is that the most older teenagers, talking about 15 years old and up, they are very hard to place as an adoption or in guardianship, because most of them have a lot of baggage. They have a lot of traumas and whatever comes with it. So the only option most of the time, is my experience, is APLA, if they are willing to cooperate with us, with the case manager.
Mm-hmm. Yeah, it is really hard for our older youth because we're looking at, and that's why I said when we talk to them about their permanency plan, whether it's adoption or anything else, to really, it should not be a one-time conversation. And it is sometimes hard for our older youth to think about having another family. And that could come in many different ways. They may still have loyalty no matter what happened to them, loyalty towards their biological, their first family. They're, worried about, if they join another family, how does that affect their biological family? Or like you said, the trauma that they've already experienced and the loss and the grief, and why would they trust anybody else? Why would they trust again? Or if they've lived in multiple homes, they've joined multiple families, or some of them have been adopted, or their plan was adoption. So there's so many reasons why it would be difficult to engage our older youth. And that's why I say it can't be a one-time conversation, and really they must be part of the plan. It's their life after all, but you're right, it is very hard to engage them at times. I'm not sure if I answered your question or what your question was, but I would agree with everything you said.
Well, because I think the majority of the teenagers probably will age out through APLA, through an alternative permanent placement or living arrangement, and because that's my experience. I don't know how it is in Delaware.
Well, I don't know. I don't have any statistics in front of me, but I do know that it does, as working in adoption for many years, the older a child, the youth gets, adoption is more challenging. That said, we're working on an adult adoption right now. We had an adoption of, we do have older youth adoption. So that is a possibility. And I think that when we have youth that want that, we must really do everything we can to make that possible and think outside the box. And a lot of times, our older youth who have engaged in the process, they find their family for us. And that really has to be part of our process and that's why I say we absolutely must engage our youth in this. And we need to have strategies that are sometimes different than what we're accustomed to, because really our youth are going to find their people, and we want to support them in the best that we can in that process. So that's why I talk about relational permanency and legal permanency. Legal permanency is adoption and permanent guardianship, but how can we safely help our youth find their people, the people that are going to support them for a lifetime? And sometimes that's our job, is relational permanency, as opposed to they don't want to be adopted, but what do they need? Because family, you can teach kids as many skills, you can give them as many workers as possible and teach them as many skills as you can, but none of that replaces family and those lifelong connections. So I just think there is something that's very important for us to do everything we can to engage our youth. And I know how hard that is. I really do know how hard that is, but they have to be part of this process. Are there any other questions about APLA? I know APLA is a tough one to wrap our heads around, I think. Okay. Any questions about the compelling reasons? I always struggled as an adoption worker with the compelling reason, and I think that a lot of people do, with a youth has been in a long-term foster placement, and they are, want to be a long-time foster parent, but they don't want to adopt, and they don't want to do permanent guardianship. And I always struggled with just landing there and accepting that, because, well, why not? Why not? And if they are unable to do that, how can they support that youth or child to find that option to not age out of foster care? So if they can't do it, how can they support the youth to? And sometimes and we've had it happen where the foster family is not able to provide permanency, but this youth is part of this family. And there sometimes is somebody else in the family who is interested in providing permanency. So that's why I talk about thinking outside the box, that I don't know that we should just land on, well, the foster parent is a long-term resource, but is not able to do permanent guardianship and foster care. I'm not saying that we should pressure the family, because that is their decision, and that adoption and guardianship are huge decisions, but I think that we should utilize that in a way to find permanency someplace else, if that makes any sense. Okay, so let's talk about permanent guardianship, which is an option for foster parents. And the intent of permanent guardianship is to create a relationship between a child and caretaker, which is permanent and creates a permanent family for the child, and often without having to terminate parental rights of the child's parents. So certain relatives or a foster parent can obtain permanent guardianship of a youth. The child must be for a foster parent to do it, the child must be in the home for at least 6 months. And the child must be 12 years or older for the foster parent to obtain permanent guardianship of the child, unless the foster parent has permanent guardianship of a sibling. So what I mean by that is, if a foster parent has permanent guardianship of a sibling and the child is 11, they can obtain permanent guardianship. But if they don't have a sibling, the child must be over the age of 12. And if a child is 14 or older, they must consent to the permanent guardianship, similar to adoption. There are so many similarities to permanent guardianship and adoption. And one of them is that the permanent guardianship must complete training and get a home study, and that is similar for an adoptive resource. And DFS cannot write this home study. It must be completed by a licensed child placing agency, which we have contracts with, so we can get that process started and done. And in order for permanent guardianship to be a plan, the division must have grounds for termination of parental rights. And many times we do permanent guardianship and the parental rights have been terminated. And there is a place for that again, goes back to the child doesn't want to be adopted, but they want to stay where they are, and permanent guardianship is an option for these youth. There are some really great benefits to permanent guardianship. Unlike guardianship, birth parents cannot go to court and file to rescind guardianship, so this is really more permanent. It's like adoption. And similar to adoption, the guardian may be eligible for a monthly subsidy, and post-guardianship supports are available. And those post-guardianship supports include training, support groups, crisis management, respite, and more. So we have some really good post-guardianship supports in place. So I think that, when I was a worker, families really struggled with guardianship or adoption, permanent guardianship and adoption, because they were fearful of losing that support of the division, that support of OCA, or the board payment even. So it's really important for families to know that there are supports in place, that the division will close their case, but there are so many supports. There's a community of people to support families, which is what makes it so wonderful. Also, if a youth is 16 years or older, when the permanent guardianship is finalized, they're going to still be eligible for those independent living services, which are so important to our youth. And this is going to be and this is similar to adoption, this is a 2-part PPC process. And I think that folks get a little bit confused about this. But first, the case is referred to the PPC for a plan or a goal change to permanent guardianship. That's the first step. So usually, almost always in permanent guardianship, you've identified somebody. It's either the foster parent or a relative that has heard about permanent guardianship, Hopefully they were able to receive some information about permanent guardianship and said, I'm interested in this. And the youth is interested in that. So Permanency Planning Committee will change that plan to permanent guardianship. And then that worker will make the referral for that home study that is required. Once that home study or family assessment, like we have so many words for one thing, but once that home study is complete, the case comes back to the PPC for approval of the home study. And that's when folks will have the opportunity to read the home study in advance and present it to the committee. Are there any questions about permanent guardianship?
Yes, I have one. I'm sorry, I keep asking questions.
I love it. I love it.
Oh, well, you said birth parents cannot apply to rescind guardianship. Can foster parents do that once they have obtained guardianship, permanent guardianship?
What do you mean? Can foster parents petition to the court? Or are you saying if the foster parent obtains, I think I understand, the foster parent obtains permanent guardianship and then down the road they decide they do not want permanent guardianship?
Yes.
Well, I would not put this as a pro of permanent guardianship that you can rescind, but at any time anybody can go back to court and rescind. We've certainly had those cases, but I don't think this should be an option of you can always rescind if you want to, because we want it to be.
No, I'm just asking because when a parent, a foster parent or whoever adopts a child, they cannot go back to court and say, here, I don't want this child anymore, here it is.
Well, yeah. And I think the same is true for permanent guardianship, but we know that both scenarios happen.
Mm-hmm. Okay.
Yeah, but that we say this is permanent. The division is closing the case. This is your child. There's tons of supports, and we hope that doesn't happen. But certainly, unfortunately, does happen. We don't view it as an option, but it does happen.
Okay.
Any other questions about permanent guardianship? Permanent guardianship is one we get a lot of questions about, and families get a lot of questions about. And I would encourage, if you're involved in a case that this is being explored, to reach out. I mean, you certainly can reach out to me at any time, but to reach out to, a lot of times the worker involved in the case doesn't know as much about permanent guardianship as a permanency worker might. And I know that permanency workers and supervisors are very comfortable and agreeable to talking to a foster parent or a relative about permanent guardianship, so that the best information is provided, because a lot of times they don't know what they're agreeing to. And never do we want anybody to agree to something that they're not going to be successful at. So please don't ever hesitate to reach out to me or any of the permanency supervisors with questions about permanent guardianship.
And Moira, this is Lauren. That's a really good point. I've done that several times with CASAs when they have either a relative or a foster parent, if the child is over 12, questioning if permanent guardianship is best for them. And so I've definitely encouraged it several times, and you're right, it's been super helpful to have the potential guardian, the CASA, the treatment worker, and a permanency worker kind of all sit down together. And that permanency worker is phenomenal at kind of laying out the requirements and the pros and cons of each permanent option. And that way the potential guardian or adoptive resource, can hear it firsthand and be able to ask specific questions, where the permanency worker is very capable and able to answer some of those questions. So absolutely, any CASA that has a situation where somebody is debating, between guardianship, permanent guardianship, adoption, involve a permanency worker as soon as possible, because they can be an invaluable resource.
Yeah, we want to make sure, thank you, Lauren, because we want to make sure that families, when they're considering this, that they have all the information. We want families to be successful. So the plan or goal that is recommended by the PPC is the division's recommended plan or goal for the child or youth. And this means that now we have to request that the court change the goal, similar to what we talked about earlier about the new reasonable efforts. So after PPC, the DFS worker will notify the Deputy Attorney General of any change in the plan, and then they would file a motion requesting the plan to be changed that would be hopefully heard at the next hearing. Any questions about that?
Can I just go back real quick?
Yeah.
Again, I mean, I'm certain that we were told this back in the days of training, but that's been a while for me. The rationale for age of 12 for permanent guardianship?
You know, Anne, that's a really good question, and I don't know the answer to that. I don't know if Lauren or Sam has any input in that. I mean, that's just what the statute says, but I don't know who or when or how that age came up.
If I remember correctly, and I don't remember why that specific age, but the reasoning was that because that's just for foster parents to take permanent guardianship of somebody 12 and older. If it's a relative, that number doesn't need to be there. And I think the reasoning was to try to encourage family member biological connection to step forward, if at all possible.
So that age doesn't count for relative.
Correct. That's just foster parent.
Okay, that's
So
that's what I thought.
Yeah, if I remember correctly, it was really to just be supportive and kind of put family first, if at all possible and appropriate.
So I just have to mention concurrent planning, because a lot of times when you come out of committee, you're going to have more than one plan. And so what is concurrent planning? It's when the committee recommends 2 or more plans or goals for a child. And you guys have all probably been involved in cases that involve concurrent planning. And you know, one of the most common examples is termination of parental rights, adoption, concurrent with reunification. And this is when we're still planning with the parents, but we recognize that we need to start thinking of another option if reunification doesn't happen. And thinking about APLA is never a concurrent goal. We do have to rule out every other permanency option before we can consider APLA. So we would not be planning side by side with APLA, kind of the last goal. Does anybody have any questions about concurrent planning? I remember, you know, I don't know, some of us have been around for a while. I remember the days that there were some judges that had like 4 plans for the youth, but and it is 2 or more plans or goals for a child. But you know, really, again, the most common example is that TPR, adoption and reunification. So I'll go through the process pretty quickly. The process is that the caseworker assigned to the case, the DFS worker, is going to do a referral in focus and send it to the supervisor for approval. And then the committee chair, who is that permanency supervisor, will that person, I say she because it is she in each county, creates the schedule and notifies the worker of the review date and time. And then that is done a week in advance so that the committee members have that referral and any documentation with the referral and have time to review it before the committee. That's best practice. So what is being referred? The information is the description of the child. Tell us about the case, when and why the child or youth come into foster care. Tell us about the family history, maternal or paternal. If the parents are absent, what efforts have been made to locate them? Do they have relatives, extended family? What efforts were made to locate the relatives? And really any work that's been done on the case plan. Tell us about the case plan. And the reason that we ask for this in advance is, again, so we can be prepared coming into committee. So that's what and then here's some additional stuff. Grounds for, what are the grounds for a plan or a goal change? And then why is this in the youth or the child's best interest? And where does the child currently live and how is that child doing? And we want folks to be prepared to talk about what the child or youth wants. When is the next court hearing? Are there pending ICPC? So I'm rattling this all off because we want as much detail in that plan in advance. And this doesn't, I'm just letting you guys know what the DFS worker puts into the referral so the committee can review in advance and be prepared with any questions. So first, it's the DFS worker assigned to the case is responsible to invite all interested parties. And the worker is going to invite the foster home coordinator, the private agency worker, if there's one involved in the case. And that would include your foster home worker or My Life CSR worker, child specific recruitment worker, if they're involved in the case. Obviously, CASA is invited, child attorney is invited, foster parents can be invited. That's more of a region specific. I think there are some counties that do not invite foster parents. We'll talk a little bit about that. But I also want to point out who does not attend PPC. Children and youth are not invited to PPC, and neither are doctors and therapists. Parent attorneys are not invited to PPC. Certainly we want their voices to be represented. So, we've had pictures are brought to the committee, letters are brought to the committee, but it's not a team meeting. So, we don't invite everybody. And really the foster parents' role is, if and when they are invited, is to detail how the child is doing in the home. And I think it's important for the foster parent to be invited because they are the immediate, they're one of the most important people aside from the child on this team. They are caring for these children, our youth, every day and night. So they can really provide detail on how they are doing in the home. But the foster parent is not going to provide a recommendation on the permanency plan or the adoptive resource. They're going to talk just about the child, how the child is doing, and answer any questions. Then they leave the meeting. They don't stay. And I'm sure you've all experienced this. And then the private agency worker, you as CASA child attorney also have the opportunity to speak, add in anything that may have been missed by what the DFS worker presents, because the DFS worker is going to present the case initially. So you are able to add anything that you want to add, and share any recommendations and answer any questions. And then at that point, after all the questions are asked, CASA would leave. They don't stay for the vote. Neither do the private agency workers. The DFS worker is the one person who stays for the vote. And they will contact any interested party following PPC to share the decision. And generally, decisions are made on the same day. So the PPC, once everybody leaves, they discuss the case based on everything that was presented and the recommendations that were made. And then they make a decision on whether to change the plan or goal. I said it at the beginning, there must be a quorum of 5 committee members, and the decision is determined by a majority vote. And again, often this is made on the same day. Sometimes the committee may request more information and they might defer their decision. The PPC sometimes outlines further steps to be taken in working with the parents, or may recommend another course of action in the case, such as concurrent planning. So sometimes a worker comes into PPC requesting or recommending one thing, but might leave with something else. Do you have any questions about that?
If I can go back just a second.
Yeah.
I was going to ask, we are speaking that a private independent foster care agency is also permitted to attend?
Yeah, so absolutely. So I think you're talking about, like, if a child is not or youth is not residing in a DFS foster home, but maybe lives in a contract home like Presley Ridge or Progressive Life, Children and Family.
Those are the two I'm speaking of.
Yes.
And I have never had one of them participate.
They are always invited.
Invited, never even invited.
Okay, no, I'm glad that you're sharing that with me. Yeah, they should always be invited, and they should be invited by the DFS worker. And we often, and Bob, I'm really glad that you said this, because part of the referral, it says, was the private agency worker invited? Was the CASA invited? Was the child attorney invited? So that is part of the referral process. And sometimes you might even hear somebody on the committee saying, well, who's the worker? Were they invited? And I often, you will reach out to the agency and say, this is the worker, they were not here, you know, letting them know. So I'm glad you shared that. They should be invited. They should be there, because that is similar to why they would be in the court hearings too.
That's precisely why I attended. There were some things that I saw as omissions that I thought were pretty important, and that is a major one to me.
That is a major one. Yeah, anybody who is working directly with that youth should be able to be ready to make a recommendation.
What happens if the two parties, if the committee disagrees with the recommendations of DFS and CASA and other parties involved?
Well, so ultimately the committee makes the decision, and that is the decision, which is why we have the committee. Otherwise, it would be a team meeting and the team would make the decision. So yeah, the decision, and that is the decision made by the committee is the internal goal.
Okay.
So
And that gets filed to the court, and the court may say, no, well, I don't accept this, but that is the internal decision. I'm sorry, Lauren.
Yeah, no, I was going to clarify just a bit. So Moira is saying that, you know, the committee meets and makes the decision if that is DFS. So if CASA or the child attorney disagrees with the decision that is made, there's going to be some legal paperwork filed anyway. So the Division of Family Services attorney, the Deputy Attorney General, will file with the court a plan to change the permanency plan. So once that's filed, both parent attorneys, if there's two parent attorneys present, and the child attorney will have to respond, whether they oppose it or support it. And if they oppose it, which would be meaning that CASA does not agree, we would explain why. And then it's up to the judge to decide. So DFS through the PPC will make file a motion to change the plan. All the other attorneys will respond with their positions, and then it lands in front of that same family court judge that has been hearing that case, and then the judge changes the plan how he or she sees fit. So there's a little bit of kind of follow-up afterwards.
Yeah, thank you, Lauren. Thank you for articulating that. And, you know, certainly we have cases, and you guys may have been involved in some of them, that goes to family court, and the judge, for whatever reason, whether somebody disagrees, does not accept the plan, and the case comes back to the Permanency Planning Committee. So yeah, it does have to go before the court. And just as a follow-up to that, any future goal or plan change must return to the PPC. So we know that plans change throughout the case, especially, you know, if a youth has been in care for a while, the plan might change. And we've certainly had cases that are in guardianship unknown resource or APLA that have come back for permanent guardianship or adoption. But that is really the purpose of the committee, is so that you, as the CASA, the child attorney, the DFS worker, you guys aren't making decisions on your own, that you're getting the support and the committee to offer direction.
But in a particular case, if one of the results is one of the items in the concurrent plan, you don't need to come back.
Correct.
It's not as though you then need to come back and eliminate the one that's not being utilized, correct?
That is correct, Bob. That's a really good point. Thank you. No, and sometimes they do that for concurrent planning so that you don't have to come back. And yeah, you're absolutely right. Excellent point. So we're going to wrap up with talking about the adoption and permanent guardianship resource reviews. But before we go there, are there any other questions related to the plan or the goal change, or anything that we've already talked about? Okay. So, and I said at the beginning, the adoption and permanent guardianship resources, this is a two-part process. First, you're going to change the plan. And once the plan is changed, then the worker is going to refer for, pardon me, the worker is going to refer for, make a referral for that home study to be done. So once the home study is completed, or I just jumped way ahead of myself, so let me back up, I'm sorry. Once you have, if you're reviewing adoption resources or permanent guardianship, the worker is going to complete a resource referral in focus. And what is part of that referral is a copy of the permanent guardianship or adoption home study that we talked about that was written by a child placing agency. And also they're going to include a child profile. And a child profile is a written document that shares all the information that we know about a child. And this is often written by the same worker who writes the home study. And the worker can present up to 3 families to be considered as the adoptive resource to the Permanency Planning Committee. And it's the committee's job to select the family that is the best connection or the family that can best meet the child's needs. And only one family is presented as the permanent guardian. So before I go further with, I'll talk real quick about what the DFS worker puts in the referral for the resource review, but just knowing that in advance that this information is provided, the referral is done a week before the date of committee. And again, this gives, all this information is provided to the committee so they have the opportunity in advance to read any home study that's being presented, to read the child profile, to read the referral, so they have all the information ahead of time, so they're not just going in and listening to the presentation. That said, that you also have the opportunity to review any and all home studies. We can't send them to you. I know that they are being sent to you, but we're not supposed to send them to you because they are owned by the agency that writes them, unless we have the permission of that agency. But I know when I was a worker, we would coordinate so that CASA and child attorneys would come in and we're able to review them in advance in the DFS office. So just making sure that you're aware, you also have access to the child profile and also should be consulted as the child profile is being written, because you will, as CASA, will have some very valuable information. Sometimes you're the person who's known the child or youth the longest, right? And have more information than often DFS does. So that child profile, you would have access to that and even should be talked to in advance when it's being written. Does anybody have any questions about that and what you're able to review prior to the committee? Okay, so, oops, I get very excited when I get my, okay, so the PPC for the referral, we want a description of the child. And this is also not just in the referral, but what is going to be talked about during the committee meeting. Is a description of the child. Why is the child in foster care and how is the child doing? Does the child have siblings and do they visit? Do they live with their siblings? Do they have the same plan as their siblings? How does the child feel about adoption? And what kind of family would best benefit the child? And these are things, again, that you're going to talk about during committee. So the home studies, again, are written by licensed child placing agency. The Division of Family Services cannot write these home studies. And there are regulations that require certain things to be in every home study. And some things that PPC is looking for is, who is this family? Well, what are their reasons for adoption? And sometimes the family is the foster parent and they never thought they thought they were fostering and didn't realize that adoption was going to be an option. And other times that's not it's not the foster parent, but somebody that we've recruited. So does the family have access to services and are they willing to participate? And those services may include medical services, therapeutic, post-adoption support, specifically if the adoption is to take place outside of the state of Delaware. We know what the post-adoption supports are in Delaware. But the question would also be, are the family willing to participate in these services? And is the family open to sibling or family contact? How will the child's culture be addressed? If something were to happen to the parent, what would the plan be for the child? And similar to the permanency referral, the DFS worker is going to invite the foster parent in certain counties, CASA, child attorney, those private agency workers, Bob, that you talked about, they should be invited too. And then the worker will also invite the person who wrote the home study. And again, if the foster parent participates, they will share how the child is doing and answer any questions, but they're not going to stay for the full presentation or make a recommendation about what family is to be selected. And the worker who wrote the home study, they will present their home study, and if there are multiple home studies, the workers do not sit in on each other's presentations. And CASA and child attorney will share their recommendations and answer questions. We certainly want to hear from you and what you know about the child and what you know about the families that are being presented, and who you think would be the best selection. Generally, PPC makes the decision the same day, but again, they can defer if they need more information, and that certainly happens. And I just looked at the clock, and I'm so sorry, Lauren, you didn't tell me we were over time. I'm so sorry.
No problem. You're doing great. If you don't mind just kind of wrapping it up a little bit, that'd be great.
We are done. There's my last slide. Anybody have any questions?
Yes, may I ask one more question?
You can.
You said, correct me if I'm wrong, if a foster parent is taking care of a foster child and wants permanent guardianship, that cannot happen until the child is 12 years old.
Yes.
What kind of permanency is left when the child has not reached the age of 12? Is that adoption?
Adoption, reunification, guardianship, yeah.
Okay.
Good question.
Well, you said guardianship, you mean not the permanent guardianship then?
Yeah, I say that, but adoption.
Okay.
Thank you guys so much for all your good questions and being here today. I'm so sorry that I went over.
No, it was just by a few minutes. So, and Moira, this information is super helpful, and I'm very grateful. Thank you so much for taking the time to present to us.
Oh yeah, my pleasure. Thank you for having me.